Good morning, it's Bob Massey. A little late for Facebook Live this week. Just sort of got away from me. I hope everybody is having a good week. You know, I get a lot of calls because I do personal injury work, as you know, in the area of slip and fall. I get people who are visiting and they'll call the office and say, Mr. Massey, I tripped and fell or slipped and fall at the casino. And I'll say, well, what did you trip and fall on? What did you slip and fall on? I don't really know. Well, what time of the day was it? It was 2 o'clock in the morning. Well, had you been drinking? Yes, I've been drinking. So I said, do you have any witnesses? No, I have no witnesses. So listen, anybody that's come to see me over the years in trip and falls or slip and falls, if I get 10 cases, I take probably at the most 2 out of 10. And here's the reason why. I presume on a trip and fall or slip and fall case that probably highly likely it will be a denial of liability by whomever owned the property, particularly a casino. But let me give you some advice on as a homeowner and as a property owner so that you understand how the mechanism of this works. First of all, your homeowner's insurance has liability coverage, meaning that if somebody's injured at your house, if you are having any work done at your house, if there's any kind of landscaping being done, if there's anything that an invitee, somebody you've invited to the house, could be exposed to, remodeling a bathroom, you have a duty as a homeowner to warn them of the dangerous condition or the condition that's much different than is normally at your place of residence. As it would be in your business, same thing. So for example, if you own a business, and let's say you have a torn carpet, and I'm not talking about an employee that would trip and fall, let's say a patron, if they trip and fall and get injured, because of the fact you had notice of that condition and didn't fix it, you have a duty as an invitee inviting somebody to your business to have safe conditions. Needless to say, if it's an employee that would trip and fall, that's a workers' compensation claim. If you own a vacant piece of property, one of the biggest mistakes people don't do as an owner of vacant property is they don't have homeowner's insurance on it, or liability insurance, I should say. If you own a vacant piece of property, you should cover it with insurance because people go on there, you get kids on there on four-wheelers, you get people that are walking across the property and they trip and fall or slip and fall or hurt themselves on your property, and you have no insurance. So when you personally experience a trip and fall or slip and fall, let's say it's a wet condition, let's say you're at a supermarket. This happens a lot. I'll get calls say, Bob, I was at a supermarket or I was at Walmart or whatever place it may be. And I slipped and fell on oil, Wesson oil, let's say, on the floor that was dropped. The defense that the owner has, i.e. any kind of retail store, is we did not have notice of the condition in a timely fashion. So let's say you're walking down a supermarket aisle and you go to grab some oil and it falls on the floor and I'm 15 steps back and I didn't see it. I'm walking and I slip and fall and hurt myself. My chance of winning on that's going to be slim and none because it just happened and the owner of the premises never had notice of the condition in order to mitigate it and fix it. So the bottom line on a slip and fall or trip and fall case is if that happens to you, immediately see if there's any witnesses around in order to corroborate what happened. Number 2, always do an incident report on the property. So you tell them for security, I want to have an incident report. The cases I've had success on slip and falls and trip and falls are common areas where people live where grass has grown over a hole. People walk across the common area, bang, they go right down and break their hip, break their leg. I had a case a few years ago where a woman, lovely lady, was walking into a pizza place and the step up and the cement area was exactly the same color. And when you took pictures of it, you could see that there's no way that somebody could tell there was a step there. Well, there's certain code violations. There's certain notice issues that should be given to a patron. So it's very fact-driven. A slip and fall and trip and fall, like any personal injury case, as it relates to liability. And what I mean by liability is fault. Who is at fault? Are you at fault as the injured person for basically being contributory negligent? In other words, seeing the dangerous condition and walking right into it anyway? Or is it something that, should have been taken care of and the property owner didn't do it? The bottom line is people trip and fall and slip and fall in Las Vegas all the time. Casinos, property owners, and people that visit your home. Always make sure, if it's commercial property, casino, get an incident report, witness statements, and pictures of the condition, assuming on what your medical condition is like. And understand that when you call us to handle these cases, I'm going to be asking you very specific questions before you come in so that I have a good sense that this is the type of case that I can help you on. Please go to our website, masseyandmassey.com, 702-870-1100. Thanks for watching.